Section 1, reconsideration denied. Now what? So, you got bad news from the Social Security Administration, or SSA. They denied your disability claim even after you asked them to take a second look. Don't give up hope just yet. You have the right to appeal again. This time you're taking your case to a higher court. This is called a hearing. It's like the court cases you see on TV. A hearing lets you stand before an administrative law judge. This judge works for the SSA, but they make decisions independently. Think of them as a referee for disability cases. They will listen to your side of the story. They'll review all the evidence. Then, they'll make a fair decision about your disability benefits. This hearing is your chance to tell the SSA why you deserve disability. But remember, this isn't about feeling sorry for yourself. It's about presenting your case with facts and evidence. Just like in my courtroom, you need to be prepared. You need to show the judge how your medical conditions prevent you from working. This isn't the time for excuses. It's about being honest, direct, and prepared to prove your case. The SSA has rules about who qualifies for disability. Your job is to show the judge that you fit those rules. Section 2. Requesting a hearing. Your ticket to the courtroom. After a reconsideration denial, you have 60 days to request a hearing. Don't waste time. The clock starts ticking the day you receive that denial letter. Missing the deadline could mean starting the whole process over. And trust me, that's something you want to avoid. You can request a hearing in a few different ways. The easiest is to do it online. The SSA website has a simple form to fill out. You can also call the SSA toll-free number. An agent can take your request over the phone. Or, if you prefer things the old-fashioned way, visit your local Social Security office and request the hearing in person. No matter how you choose to request your hearing, make sure you get confirmation. This is crucial. You need proof that you took this important step within the deadline. Section 3. Confirmation is key, don't leave it to chance. Imagine this. You think you requested your hearing on time, but something went wrong. Maybe your online form didn't go through. Maybe the SSA agent didn't process your request correctly. Without confirmation, you have no proof. You're left wondering if you'll even get your day in court. That's why getting confirmation is so important. It's your insurance policy. It proves you did your part. If you request your hearing online, print out the confirmation page. If you do it over the phone, write down the date, time, and name of the agent who helped you. And if you go in person, ask for a receipt. Keep this confirmation safe. It's a vital piece of your disability case file. Just like I need evidence in my courtroom, you need evidence to support your claim. This confirmation shows you're serious about getting your case heard. Section 4. The hearing prep begins. Gathering your ammo. Once you've requested your hearing, the real work begins. This is where you gather all your evidence. Think of it like building a strong case in court. You need to be organized, thorough, and ready to fight for your rights. The SSA will schedule your hearing several months out. That might seem like a long time, but it's not. You have a lot to do. Don't wait until the last minute. Start gathering your evidence as soon as possible. The more prepared you are, the better your chances of winning your case. The first step is to contact a disability attorney. They're like your legal guide through this complex process. They know the ins and outs of disability law. They can help you build a strong case. Section 5. Medical records. Your health, your evidence. Your medical records are the backbone of your disability case. They tell the story of your health. They document your conditions, your treatments, and how your disabilities affect your daily life. Without strong medical evidence, your case is weak. Your attorney will help you gather all the necessary medical records. This includes records from all your doctors, specialists, hospitals, and clinics. Make sure your attorney has a complete list of your medical providers. These records need to be well organized and easy for the judge to understand. A jumbled mess of papers won't help your case. Your attorney will make sure your records are in chronological order. They will highlight the most important parts for the judge. Section 6. Doctor's orders, why medical opinions matter. While your medical records tell the story of your health, your doctor's opinions provide critical context. They can explain how your conditions limit your ability to work. Your attorney will contact your treating doctors. They'll ask them to complete specific forms. These forms ask about your ability to sit, stand, walk, lift, and concentrate. They also ask about your mental limitations. These medical opinions carry a lot of weight with the judge. Judges want to hear from the medical professionals who know your conditions best. They want to know how your illnesses or injuries prevent you from working a regular job. Section 7. Hearing Day. Your time to shine. The day of your hearing can be nerve-wracking. It's natural to feel anxious, but remember, you've prepared for this. You have a strong case and a skilled attorney by your side. You have options for attending your hearing. You can appear in person, which allows you to speak directly to the judge. You can also appear by video conference, which offers convenience and flexibility. Or you can choose to appear by phone. No matter which option you choose, make sure you're in a quiet, private location. Dress respectfully, as you would for any court appearance. Be prepared to answer the judge's questions honestly and directly. Section 8. Making your case. Clear, concise, and compelling. During the hearing, your attorney will present your case to the judge. They'll explain why you're unable to work, they'll present your medical evidence and highlight the key points. You'll also have the opportunity to tell your story directly to the judge. Speak clearly and concisely. Explain how your conditions affect your daily life. Be prepared to answer the judge's questions about your ability to work. The judge may ask you about your past work experience. They may ask about your daily activities. Be honest and straightforward in your answers. Don't exaggerate your limitations, but don't downplay them either. Section 9. A winning strategy. Preparation is key. The key to winning your disability hearing is preparation. By working closely with your attorney, gathering strong medical evidence, and presenting your case clearly and honestly, you'll significantly increase your chances of a successful outcome. Remember, the judge's job is to determine if you meet the SSA's definition of disability. Your job is to provide them with the evidence they need to make that determination in your favor. Winning your disability case can be life-changing. It can provide you with the financial security you need and deserve. So, don't leave your fate to chance. Prepare for your hearing like your future depends on it.